Hello again, it's Tom Logan, attorney from Doylestown, and I thought it'd probably be a good idea today to follow up on something I talked about in a previous episode. I'm calling these episodes now. And that is what happens if you do not take a chemical test when you've been asked to do so by the police after having been arrested for DUI. And what happens is that the police will read you the form called the DL26B form. They will ask you to sign it. And if you sign it, or even if you don't, and you do not take a chemical test, meaning you, for any reason, don't take the test. Either you refuse to answer the cops when they ask you to take the test, you ask to talk to your mom, you ask to call a lawyer, you ask to have the form reread to you 17 times. If any of those things happen, it's deemed a refusal because crazily enough in Pennsylvania, you do not have the right to call an attorney before deciding whether you wish to give blood on a chemical test. You don't have the right to call your mom. You don't have the right to call your brother. Instead, if you do anything other than take a test, even if you have a fear of needles, if you do anything other than take a test, it is deemed by law a refusal. Well, can be deemed by law a refusal. More on that later. And what happens then is that the police mail in the DL26B form to PennDOT. PennDOT receives it, processes it, and then they send you a terrible letter. That terrible letter will inform you that your driving privileges are suspended for either 12 or 18 months, depending on your prior DUI record. And it will tell you the precise date and time on which your suspension will begin. And if you do nothing upon receiving that letter, you just receive it, you don't respond to it in any way, that's the day on which you have to stop driving. And if you keep driving, then bad things will happen to you. Very bad things will happen to you, especially if you get caught. Those things can include mandatory jail time, an additional 12-month license suspension, just a parade of terrible, horrible things. There is, upon receipt of that terrible letter, a few things that you can do to stop that suspension from taking effect. You have 30 days from the day that you get that letter to file an appeal to the Common Pleas Court in the county in which you were arrested for DUI. And what you should do if you have refused to test, arguably or not, is to contact a qualified lawyer, me for example. And you can call me anytime, 215-345-9500 or 765-491-2730. All consultations are free.